Welcome to Flash Buzz News. Today, we're diving into the unprecedented scenario of Donald J. Trump running for president despite felony convictions. How do existing laws interact with his eligibility? What implications could this have for our democracy? Stay tuned as we unravel the complexities of Trump's controversial run for the White House. Make sure to subscribe and hit that notification bell for the latest updates. Donald Trump has been convicted of falsifying business records to cover up a hush money payment to a porn star. On top of that, he faces dozens of other felony charges. Despite these legal troubles, Trump remains a viable presidential candidate under current US law. This scenario raises numerous legal and constitutional questions that the US has never faced before. How will this legal drama unfold as we move closer to the 2024 election? Stay tuned as we explore all the ramifications and possibilities. The United States Constitution sets very few eligibility requirements for presidential candidates. At least 35 years old, natural-born citizens, and living in the country for at least 14 years. There are no limitations based on character or criminal record, meaning Trump meets the constitutional requirements to run. While some states have laws prohibiting felons from running for state and local offices, these do not apply to federal positions. Previous attempts by states to impose additional requirements on federal candidates have faced legal challenges and been blocked by courts. The Constitution is clear: Trump can run for president, despite his convictions. States cannot impose additional substantive requirements on candidates for federal office. This principle was highlighted in a 2019 California case where the state tried to require presidential candidates to release their tax returns to appear on primary ballots. However, a federal district judge blocked the law. The California Supreme Court also blocked it, citing violations of the state's constitution. This case underscores that while states control the time, place, and manner of elections, they cannot add new eligibility criteria for federal candidates, vital in the context of Trump's candidacy. The Supreme Court ruled that states cannot bar Trump from the ballot under Section 3 of the 14th Amendment, which disqualifies those involved in insurrection from holding office. The court decided only Congress has the authority to enforce this rule for federal positions. This legislative limitation means the 14th Amendment remains separate from any criminal charges, and convictions in election-related cases would not disqualify Trump from running for president. This distinction underscores the complexity of applying the 14th Amendment in the current political landscape. Imagine this: Donald Trump is elected president, but remains behind bars. He would still legally qualify to serve as president despite his imprisonment. However, this would undoubtedly plunge the country into a significant legal crisis. Questions arise about the 25th Amendment, typically used when a president is incapacitated. Trump's loyalists in the cabinet would need to declare him unfit for office, or he could argue that his imprisonment hampers his presidential duties, setting off another court battle. Donald Trump could attempt to pardon himself if re-elected, with significant limitations. A presidential pardon can address federal charges, but not state charges. So, his convictions in New York and Georgia would remain unaffected. Even more extraordinary, could President Biden pardon Trump on his way out? These questions unveil the unprecedented legal labyrinth surrounding Trump's candidacy. In summary, Trump's candidacy raises unprecedented legal and constitutional questions. Despite his convictions, he remains eligible to run for president, even from prison. Stay informed and engaged with these developments. Like, comment, and subscribe to Flash Buzz News for the latest updates and in-depth analysis.